Surrogacy Act. According to Surrogacy Act, a married couple can opt for surrogacy only on medical grounds, means when the couple is medically unfit to produce a child. This act was introduced in Lok Sabha on July 15, 2019 by Dr. Harshvardhan, and this law or act was imposed by government finally on 17th December 2021. What are the regulations of surrogacy? This bill prohibit commercial surrogacy, which means it prohibit the monetary compensation to the surrogate mother. Means surrogate mother could not earn through surrogacy, but the medical service will be provided and insurance coverage will be provided to the surrogate mother. And allosteric surrogacy will be allowed. What does mean by allosteric surrogacy? It means there will be no monetary compensation to the surrogate mother. When surrogacy will be permitted and when it will not be permitted, what are the conditions when a couple will be permitted to opt for surrogacy? For intended couples who suffer from proven infertility, means healthy eggs are not produced or sperm count is low, and couples went through multiple IVF intra vitro fertilization and they are not able to produce a child. In that case, couple is eligible. Allosteric conditions, if there, then a couple is allowed to permit for this surrogacy, not for commercial purpose, means you could not sell a child, you could not produce a child for prostitution purpose, and you could not earn through surrogacy, and you could not vend multiple surrogacy in one lifespan. For any condition, this is specified through regulation, means couple has AIDS, for example couple has AIDS, or mother is mentally unhealthy, or she has one fallopian tube, or she has endometrium issue. Many things could be there. If medically unfit couple is there and they are certified medically unfit, then they are eligible for surrogacy. What are the eligibility criteria? A couple that is intending to opt surrogacy should have a certificate of essentiality and certificate of eligibility. A certificate of essentiality will be issued upon fulfillment of following condition. First one is a certificate of proven infertility of one member, means one partner or both the partner, from a district medical board. Second, an order of percentage and custody of the surrogate child passed by magistrate court. Third, insurance coverage for a period of 16 months covering postpartum delivery complications for the surrogate mother. And certificate of eligibility will be issued when the couple will fulfill the following condition. First one is couple being Indian citizen and married to at least 5 years and between the age of 23 to 50 years old. Wife should be in between 23 to 50 and male should be 26 to 55 years old. They do not have any surviving child biologically or adopted or surrogate. This would not include a child who is mentally or physically challenged or suffered from life-threatening disorder. Other condition that may be specified by regulation according to this Surrogacy Act. These are the eligibility for the couple who is going to opt for surrogacy. But what are the eligibility for surrogate mother? Surrogate mother should also obtain a certificate of eligibility from an appropriate authority. Surrogate mother should be a close relative of the couple and she should be married woman having a child of her own and in between the age of 25 to 30 years old. She should be surrogate only once in her lifetime. She could not surrogate multiple times in her life. And she should possess a certificate of medical and psychological fitness for surrogacy, and she could not provide her own gamete, means she could not provide her own ova or egg for surrogacy. What are the appropriate authority? Appropriate authority of surrogacy allowance or for providing certificate. The central and the state government shall appoint one or more appropriate authority within 90 days of the bill becoming an act, and this bill become an act on December 17, 2021. After that, central state government appoint and appropriate authorities, and the function of appropriate authorities are granting, suspending or cancelling this registered or certified surrogacy clinics, and enforcing standard for surrogacy clinics, investigating and taking action against provision of the bill, and recommending modification to rules and regulation. What are the criteria for registration of surrogacy clinic? If I am going to register for a surrogacy clinic, then I should follow the procedure and I should be registered by the appropriate authority, and I should apply for registration within a period of 60 days from the date of appointment of the appropriate authority. Then there are some boards, national and state surrogacy boards. NSB, National Surrogacy Board, and SSB, State Surrogacy Board. Function of NSB, that is the National Surrogacy Board, is advising the central government on policing matters that is related to surrogacy and laying down the code of conduct of surrogacy clinic. And SSB, that is State Surrogacy Board, has a function of supervising how does these surrogacy clinic are functioning. Are they imposing the law or they are following the order or not? Then there are some percentage or abortion of surrogate child. A child who is born out of a surrogacy procedure will be deemed to be the biological child of the couple only, it does not belong to the surrogate mother. And an abortion of the surrogate child, if required, it will be done with a written consent of surrogate mother that I am willing to abort this child, and the authorization of the appropriate authority, and this authorization must be under the Medical Termination of Pregnancy Act that was passed in 1971. Further, the surrogate mother will have an option to withdraw from surrogacy before the embryo is implanted in her womb. For example, I have signed a contract for surrogacy, but that embryo is fertilized and in her blastoma stage, but I am not ready for surrogacy purpose. Then before implantation, I can refuse for surrogacy. Then what are the penalties and when these will provide? These will provide or these will imposed in case of undertaking or advertising commercial surrogacy, exploiting the surrogate mother, abandoning, exploiting or disowning a surrogate child, selling or importing human embryo or gamete for surrogacy is prohibited, and penalty is of imprisonment up to 10 years and a fine of up to 10 lakh rupees. The bill specifies a range of offences and penalties for other contravention of provision of the bill. Finally, what are the controversies behind this law? It does not allow single men, women, or gay couple to go in for surrogacy, and there is an issue arise against this Transplantation of Human Organ Act. And if we see, then there are chances of resolving this act or for amendment of this act if there will be mass build up, or if there will be the criticism of this act will held, and if government want to include different categories of parents into it, then there is a possibility of amendments.